Okay, good afternoon, everyone. Thank you very much for joining us at today's session. Sorry, today's session. I would like to introduce our guest speaker, Zahava Schechter, an attorney, and I will turn it to Zahava.
Yeah, I know, I can still hear it, so it doesn't really work. Okay, so if you want to go outside, go outside.
No, I can't go up.
Maybe everyone could mute yourselves. Thank you so much.
Right. So I will turn it to Zahava to introduce herself and tell us about today's topic and what we can learn from her.
So good afternoon, everyone. I'm Zahava Schechter. Can everyone hear me?
Yes.
Yes. Can you see my screen?
Yes, we do.
Very good. Now, if I page down, hold on. Well, if I go this way, can you see a different page than what you just saw?
Yes.
Questions? Okay, great. So we're going to start. Hi, everyone. I'm Zahava Schechter. First, I'd like to thank Mariana Fradman and the New York City Paralegal Association for inviting me back again to speak to your members on this very important subject. I hope everyone is well. I want to say that Mariana told me this is an advanced Trust and Estates Administration presentation. What that means is I am presuming that everyone who is attending has a basic understanding of estate administration as well as some estate planning. If you do not, don't give up. It'll be okay. I can help you, but just know that's where we're starting from. So whether you are an attorney, a paralegal, working in the trust and estates field, I hope this will be informative and interesting for you. So let's get started. If you have a question, please type your question in the chat box or feel free to call me or email me afterwards. Okay, so who am I? Very briefly, an attorney with more than 30 years experience. You see my areas of concentration in my practice. Estate planning before people die, preparing for inevitable death, certainly, and possible sickness, as well as administration after people die, and litigation, which is when lawyers make money because people can't get along, which is unfortunate. I also do real estate conveyances and some business law. If you like to listen to podcasts, I do host a podcast called the LA Law Podcast. You can listen for free on any of Google or Apple or Stitcher, anywhere you get your podcasts. I also have, if you really are interested in trust and estates and want to hear more from me after this, I have a LinkedIn page. There's my LI Law Podcast website. I have a YouTube channel, so you can learn lots of stuff. I want to start, before we go into estate administration, with something I do for every client who comes in and says, someone in my family or a friend or whomever died. The first place I go is the New York State Office of Unclaimed Funds. If you are unfamiliar with this website, make yourself familiar with it, because loads of clients and friends and family have found money there, lost money. Sometimes you have a bank account and the institution doesn't know where to find you. Maybe you've changed addresses. So you can look for yourself, for your family. It's not privileged, for your family, for your clients, whatever. It's a great place to go, and I hope you find some free money. Okay, we are moving into estate administration. That means someone has died, and we will talk about that, but I just want to make sure that we all know the basic documents of estate planning. So in order to have a successful administration, it often goes hand in hand with a successful planning process. So the documents effective while you are alive that are part of planning are the healthcare proxy, the durable power of attorney, which law changed June 13th of 2021. There is a new law in place with new rules, and an inter vivos trust. That means during your lifetime. Effective only after you are deceased, the last will and testament. Why do we call it that? Because you can make a will today, tomorrow, the next day. The only one that's effective, they could all be valid, but the only one effective is the last one, and certainly a testamentary trust. So the problem with a testamentary trust is if the will is not accepted for probate and there is a testamentary trust, testamentary means part of the will. If there is a testamentary trust, that will not be valid either. So you kind of take your chances when you make a testamentary trust that there may be a problem with probate. So I personally like inter vivos trusts, but that's just my opinion. Also, I want to, before we move on, I want to give a basic definition if you're not familiar with this. When we talk about estate, that means someone has died. So it would not be appropriate to say the estate of Zahava Schechter, because thank God I'm alive today. Estate means someone has died. And I hope you don't mind, I'm going to intersperse some cartoons through here, because I always think it's good to have a little bit of levity and to show that we can kind of make fun of ourselves. So here we have Mr. Frosty. It's March, time to talk estate planning before he melts. So a lot of times, you know, I don't know how many of you, I'm not asking for the information. I don't know how many of you have done estate planning. Studies in the United States have shown only 4 out of 10 people. So 40% of adults, meaning defined as the age of majority in New York State, 18 years or older, only 40% of people have done any estate planning. So let's hope for Mr. Frosty, he can do it before he melts. So we're going to move directly into estate administration. And hopefully you know that there are 2 legal terms of art that we use. Testate, meaning someone died with a will. Intestate means they died with no will. In New York State, the only court of competent jurisdiction for someone who is deceased is the surrogate's court, surrogate, apostrophe S. Please don't write just surrogates without the apostrophe, surrogate's court. And it depends on where that person resided. So it doesn't matter if they have vacation homes or if maybe they would go to visit upstate, you know, their friends, even if they died then, what address was on the driver's license, on the tax return, et cetera. So that's what we look for. And when you have a will, you offer it for probate. Probate is, think of acceptance, meaning just because somebody has a will doesn't mean that it's going to be accepted by the court. A lot of people think that fallacy is true, but it's not. An administration is when you have no will. So what happens to the power of attorney and healthcare proxy after death? They are no longer valid. So I have people who call me and say, oh, so-and-so just died. I'm the agent under the power of attorney. I'm going to still do stuff. And I say, no, no, no. Once someone dies, the power of attorney and healthcare proxy are no longer valid. Who has standing to file a petition? Again, we're going to focus on estate administration. Somebody has died. We're going to look at SCAPA, that's Surrogates Court Procedure Act, Section 1001. We're going to look at that in one moment. And there is a specific list of who has standing. Here we are presuming there is not a will. If you have people in your family or your clients, let's say, don't have family, maybe they want to make a friend, either fiduciary, that means executor or administrator, executor if there's a will, administrator if there isn't, or beneficiary, you have to leave a will. Otherwise, New York State is going to determine the order, and we're going to talk about who are the beneficiaries, the default beneficiaries as well. We talked about where the petition is filed, only in surrogate's court in that county where that person resided. Who needs to be notified when a petition is filed? So whether it's a probate proceeding or an administration proceeding, all distributees have to be noticed. So who is a distributee? Anyone who would take but for the will. So if there is a probate proceeding, and let's say I don't leave anything for my husband or my children, but they are my next of kin, right? My heirs at law. We're going to look through the statute in a moment. They must receive notice. I have a case like that right now where the husband and the daughter basically are out of the will, and we're going to do, this is beyond the scope of this conversation, but we're going to be doing it's a will contest under SCAPA section 1404, try to throw out the will. So you can't just say, okay, those people were kept out of the will, we're not going to let them know. No, all distributees must be notified. Who has the power to act? When? How? Okay, so I get a call from someone. Rick named me a executor under the will. I'm ready to do something. Well, you can't do anything. Let's say Mariana is the nominated executor. She has no power until she's appointed and receives letters testamentary or letters of administration if there is no will. So just because you're the nominated executor, that's what we call it, the nominated executor under the will, you have no power until the court gives you power. Hopefully that is clear. Here's our next cartoon, reading the will. To my loyal estate planning attorney, I leave my children a complicated series of trusts that will generate huge legal fees. Okay, well, that's what happens when people don't plan well. I would say to you, if you're planning and you have complicated series of trusts, you should try to simplify them, but that's for another conversation. Who qualifies to be the appointed fiduciary, either executor or administrator? So in this cartoon, it turns out fiduciary means you have to give it back. So I want to go through what a fiduciary means. That means whether you are a beneficiary or not, you have an obligation on behalf of all the beneficiaries, not just yourself, to preserve the assets, not to have waste, and to make sure that you don't abscond to Tahiti with all the money. I am actually finding, and I'll talk about Queens because I have a number of administration proceedings right now in Queens. On every administration proceeding, meaning again, intestate, no will, on every administration proceeding, a bond is being required. I'm seeing that. I don't know if that's because there have been some bad apples and people have absconded with money, the fiduciary has absconded, but I'm seeing it on every case. I don't think it's just me, but anyway. I want to talk about who is qualified before we say who has order, who is order of priority. So this is SCAPA section 707. If you do this kind of work, you probably know the section, who is eligible to receive letters. So we're going to talk about who is not eligible first, an infant. So an infant isn't a baby. An infant is someone under the age of 18, 18 being the age of majority in New York State. So someone, even a child, an adult, well, we think of, an adult child, but a child under the age of 18 is an infant. An incompetent. Incompetent means mentally. We're never talking physically, and it means adjudicated. You have to be adjudicated as an incompetent, whether in a Section 8, Article 81 matter in Supreme Court or otherwise. But not just because I have another case right now where someone has autism or is on that spectrum and has Asperger's. That person is not incompetent. She's fully competent, and she just finished college and can handle her own affairs. So that's not incompetent. We mean truly adjudicated to be incompetent. This is very interesting. I have a case now with a client from Israel, and in the past, I want to tell you what I've done, but we're going to review this quickly. A non-domiciliary, what does that mean? Somebody who does not live in the United States. You don't have to live in New York State, but someone who does not live in the United States. Alien. So what does an alien mean? So it's interesting. When I had a case in one of the, I think in Kings County, and I had a French executor, even though she was also a United States citizen, we had to have a co-fiduciary. Do you see there? Or one who shall serve with one or more co-fiduciaries, at least one of whom is resident in the state. So that's what I think it was Kings required me to do. I'm pretty sure it was Kings. But I have a case right now in Westchester, and Westchester defines alien as someone who is not a US citizen. Okay, interesting. So even if that person has not lived in the United States however many years, or as you may know, if you are the child of US citizens in another country, you're born in another country, you automatically get citizenship. So I think that's really interesting. So be aware of this. If you, in your practice, if you start seeing people from outside the country, be aware of this situation. If a co-fiduciary has to be appointed, it must be someone who is a resident of New York State. D, a felon. Okay, so what is a felon? Do you think that's someone convicted of a crime? It's actually not. It's someone convicted of a felony. Meaning, if the proposed fiduciary has a misdemeanor conviction, we're not talking about accused, we're not talking about charge, we're talking criminal conviction. If the proposed fiduciary has a misdemeanor conviction, we're going to go to E in a second. That doesn't automatically knock them out of the box. A felony does. Okay. E, one who does not possess the qualifications required of a fiduciary. Well, I guess you can argue, depending on what the misdemeanor conviction was for, that E may knock that person out of the box. But again, every situation is fact specific, but be aware, if you have someone come to you and that person has been convicted of something, or there's a problem, a moral, ethical problem there, Even if there is a charge currently, but there's no conviction, I think you have to be careful. Look at number 2, persons ineligible in court's discretion, someone who cannot read and write the English language. That's in the court's discretion, but be aware if you have someone from another country, maybe someone who's an undocumented person, you may have trouble here, who doesn't speak English, that is, I'm sorry. Okay, so now let's look at SCAPA 1001. And again, I want to go back for a second to where I mention it. Here we go. Who has standing to file a petition? That means what is the eligibility to file a petition? And here we go. So it goes first according to who are the distributees. So, and again, you're not a felon and you haven't done anything wrong, etc. Surviving spouse. What does that mean? That means number 1, you have to be legally married. New York State, this is not a domestic relations course, not a matrimonial law course, but class, but surviving spouse means you are legally married, not that you have a significant other. And New York State does not recognize common law marriage. Okay, if you have a surviving spouse who checks off all the boxes, that person will win no matter what. Doesn't matter who's after that, that person will win. And then you see the order as it goes on. I do want to, we're going to talk about kinship in a little bit, because if there is someone who is a first cousin, unfortunately, that person will not be appointed. So anybody before a first cousin, meaning up to a brother or sister, or even a nephew, you have a chance, but not a first cousin. So here, why? Because when letters are not granted, who gets the appointment? The public administrator. Very annoying. I have to tell you, I have 3 cases right now with the Queen's public administrator being fiduciary. I have first cousins in all of those cases. And even though, and we have to do, get a genealogist report, and we're going to kinship hearings on all of those matters, the public administrator makes a nice amount of money on these cases. And just be aware that if there is no one closest, we're talking distributees, heir at law, no one closer than a first cousin, public administrator automatically steps in. So who inherit, we've just talked about who the fiduciary can be. Who inherits from the decedent when there is no will? There we look at EPTL, Estates, Powers, and Trust Law, section 4-1.1. If there is a spouse, first of all, if there's a spouse, no issue, the spouse gets everything. Issue being children, that's adopted, natural, biological, or legal. If there's a spouse in issue, the spouse gets the first $50,000 and half of the rest, and the children get whatever's left. I do want to say, I didn't go into it here, but there are issues of exemptions. The spouse also gets a car up to $25,000 in value. That's not part of this equation. Also gets certain household items and cookery and musical instruments. The statute goes on to that, but you see how it goes and who gets what. So if you take a typical family, dad, mom, so husband, wife, and 3 children, if dad dies first, mom gets beyond the $25,000 car and the other items. Mom gets the first $50,000 and half of what's left, and the 3 children share 1/3 each, the other half, meaning they're getting 1/6. Hopefully that was clear. Moving on. No, you can't get a $5 advance on your inheritance. Actually, what's interesting is even if you promise someone that you're going to give an inheritance, I can say that. I can say, Rick, I'm giving you money for me. And then there's no money for you in the will. You can't sue me. There's no consideration there. So when I say consideration, again, I'm not talking about being nice. I'm talking about bargain for exchange. I'm presuming this is an advanced class. Okay, so what happens when a beneficiary is incompetent? Oh, this is a major problem. I don't know how many of you have reached this, not only because it could throw the person off any governmental assistance, which is really sad when that happens, because then who's going to act on behalf of the person who is incompetent? Again, we're talking about a mental incompetence, not physical, and that applies where the beneficiary is under the age of 18 or mentally incompetent. So a guardian ad litem comes in. I don't know if you've had experience with these people. It's very random. Usually it's someone whom the surrogate likes or has worked with before. The surrogate has full power to appoint whomever he or she wants to. And who pays the fee of the GAL? The estate, of course. Everything is paid by the estate. So you just keep paying money out of the estate. The beneficiaries get less and less, but there's nothing you can do. So what happens when there's no immediate family to inherit? When I say immediate, we go back to, hold on a minute. Nope. Hold on, we go back to here. This is immediate, up to number 5. So what happens when there's no one like that? Hold on, I'm so sorry. Here we go. A kinship hearing is held in front of a referee to determine who are the distributees. Now, what's interesting here is, let's say you take me, right? So Zahava had a mother and father, and the mother side, the maternal side, is entitled to half. This is presuming there's no will, of course. If there's a will, we're not doing this, but the mother side gets half and the father side gets half. So each side has a portion of that money. So let's say there's one member of a class on one side. So on the maternal side, mom's side, there's one person. Then that person is getting the whole half if that person proves that he or she is my next of kin. On the father's side, let's say there are 20 people, then they're only going to get 1/20th of whatever that half is. Follow what I'm saying? So it's not like everybody, it's not a class within all of my next of kin. It's you divide it in half and each side has a half interest. By the way, let's say Mariana is my first cousin, and Rick is also my first cousin on my mother's side. And Rick passed, and Rick left a child, an adult child. Does Rick's adult child take in his place? Is this a per stirpes event? So I've already written it doesn't apply. No. So Rick's line is out. You have to survive. So only Mariana, she's going to cut off my class. And Rick's family is out. I've had that happen a few times. Okay, I want to talk just for a moment about this section of SCAPA, section 2225. I really suggest if you work in this area that you read it yourself because it's a lot of legalese. But the bottom line is you need to know that the court determines who the distributees are. So what happens if Mariana is on my maternal side and there's no documentation, or we don't know, maybe Mariana had a sister and she's missing and we don't know what happened to her? Whose obligation, who has the burden to prove the kinship? Well, Mariana, not the public administrator, not the court. So if you are a potential claimant, that's what you're called, a claimant, you have that burden. That's why genealogists make money. And I'm working now with 2 genealogists, and they have specialties. Like one of the genealogists I'm working with in that area, some of the family members is a Jewish family. Some of the family members died during the Holocaust. And this genealogist is an expert in finding people who died in the Holocaust. So that's why we're working with him. But just know you have a high burden. So make sure that you're working with someone if you can't prove it yourself. So how many lawyers does it take to change a light bulb? And the question becomes hourly or flat fee. So the reason I included this cartoon is because people will often ask me when they call me about handling an estate administration, how much will this cost? Are you asked that? I don't know if you're asked that in your practice. How much will it be? Well, I have no idea because I do charge hourly. It's not up to me. It's up to the court. It's up to whether your siblings are going to play ball, or if they're going to fight and there's going to be a will contest. How do I know? So while many of you who also do real estate know that generally, although I have a colleague who does charge hourly on real estate, generally flat real estate matters are flat fee. Estate matters are not. I do know of some firms that do flat fee very high. They charge like 6% of whatever the value of the estate is. The estate could be millions of dollars. I think that's too much. I just charge hourly. But anyway, that's my take on fees. So you might be thinking, well, how does a probate proceeding differ from an administration proceeding. Let's talk about costs. So which is going to be higher? No question, administration is higher. It's going to be, although the filing fee is the same, there might be court appearances. You're definitely going to have a bond, which you have to pay the premium every year. You need family tree affidavits. You need all kinds of things. I had an administration where everybody was fighting because, you know, unfortunately, money brings out the best and worst in people. Everybody's fighting and they all want their share. And it just dissipates. It's a waste of estate assets. So certainly an administration is more expensive. How about time? Oh my gosh, administration takes so much more time. There might even have to be a citation issued. I'm presuming you know all these words. If you don't, sorry, you can ask me after. But anyway, you know, if it's plain vanilla probate, and you know what I mean by that, whether it's a surviving spouse or children, and that's it, you can go pretty quickly. During COVID, obviously, it's been longer as people, as court personnel either left or stayed home or whatever the situation is. But probate is much faster than administration. The quantity and type of documents required, it's just voluminous with administrations. Fiduciary bond we talked about. You must, with an administration, if you have a bond, you must do a fiduciary accounting. Even, you know what, that is not informal really, although I'm doing right now where there's a bond on an administration, I'm doing a fiduciary accounting, which is informal, but informal in that I haven't yet presented it to the court, but it will have to be signed off by the court in order for the administrator to be discharged, and you need a receipt and release. Remember that when you represent someone in an estate proceeding, whom do you represent? So you're not speaking, but you don't represent the estate and you don't represent the beneficiaries. The only person you represent is the fiduciary. That's it. So my job is to keep my fiduciary from going to jail or from doing the wrong thing, etc. So all of this is just so much more expensive. So the bottom line is get a will. Tell your family to get a will. Tell your clients to have a will, plus the power of attorney and healthcare proxy, of course, but we're not talking about that now. Just much more expensive with administration. Now let's talk about probate assets versus non-probate assets. So as you know, probate assets means it goes through the will. Non-probate assets do not go through the will. However, if you have a bank account, and I give examples, bank account or an insurance policy, and you name someone who is either predeceased or you don't name anybody at all, it's going to default to your estate. What a dumb thing to do. Listen, if you name someone, everybody here, you have accounts, go and check. Do you have beneficiaries, primary and contingent? Because if I'm Mariana's beneficiary on her account, all I do is bring to Chase Bank her death certificate and my ID. And you know what? I get the money on the spot. Isn't that sweet? That's great, right? But if none of that happens, if Mariana didn't make the plan and no one is named beneficiary, or she named me, I predeceased, or I don't know, whatever the problem is, it's going back into her estate, and then we really need to probate that. Also, I'm not talking in this presentation about estate taxes because we don't have enough time, but I just wanted, I see it's half an hour already. The New York threshold, meaning the amount under which you do not pay estate tax is a little more than 6 million at this point, and there is no portability. You're probably aware of that between spouses. And for federal, it's over 12 million. But the reason I say to you that estate taxes are important is because, as you may know, and actually this brings me up to something else, as you may know, between legally married spouses, and that includes same-sex legally married spouses, there is no tax on transferring anything. So I could give my husband trillions of dollars, whether I'm alive or dead, and he pays no tax, which is great. And also, I hope you know, there's only one person you cannot disinherit. Again, one person you cannot disinherit, that is a legally married spouse. The legally married spouse is entitled to not less than 1/3 of the decedent's estate, the spouse's estate. That's called the elective share. I also didn't go into that here because we don't have time, but I'm just giving you examples. I think this is the last cartoon, not sure. The contested will. If you have a contested will, the only one who wins is the estate attorney. Why? Because I get to charge more. I mean, it's just unbelievable when people fight and they rather give the money to the lawyers than keep it themselves. So I do want to talk about special considerations where family members or beneficiaries receive government benefits. You really need a longer conversation, but this is a problem. If you're handling an estate and there is a family member who receives government benefits, this is a problem, and you certainly need to deal with that. And also Medicaid will put a lien against the estate. There's a lot going on here. So just be aware, if you see that, bells should be ringing in your head like bing, 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 I got to deal with that. Don't just distribute money. Okay, 2 quotations by Benjamin Franklin. In this world, nothing can be said to be certain except death and taxes. Very true. And by failing to prepare, you are preparing to fail. So I hope that this is your action call to, number 1, prepare your own estate plans. Number 2, I think 2, 3, whatever we're up to now, talk to your clients and make sure that their affairs are in order, and it will make their estate administration so much better. And if you have a question, I'll look, I see if there's one chat, you feel free to contact me. My contact information is there. And now I'm going to stop my screen share. Hold on a minute. How do I stop my screen share? And I don't know how to do that. Hold on 1 second.
It should be on the top.
What? Oh, stop share. There we go. Hi there. Okay, so let's see. If a power of attorney was signed prior to June 2021 but not revoked, is it still enforceable? I have a question, Mariana. Did all of the successor agents sign before June 2021?
Let's assume yes.
Okay, so I would, and is that attorney who executed, I'm presuming there was an attorney, it wasn't like an off the internet kind of deal.
Yeah.
Is the attorney still around?
Let's assume, let's do both scenarios.
Okay, if the attorney is around and if you have a problem, you go to Chase Bank where you have an account and Chase says, no, this is the old power of attorney, then the attorney can write an opinion letter. The attorney who executed the document can write an opinion letter saying, I drafted and executed this power of attorney, which did comport to the prior law from 2010. What I have done is send all of my clients letters since June 2021, and I send update letters from time to time saying you really should just make a new power of attorney because the changes are substantial. However, even I would say for those people who were my clients, you're still in good stead because one of the major changes was now the power of attorney has to be witnessed, where before it was only notarized, and I always had mine witnessed. So you stand in good stead if you're my client. How's that for an answer?
It's a great answer. What happened if a person who signed is not able to sign anymore?
So durable means as long as you're mentally competent at the time that you executed, there is no problem later on. If you later become incompetent, et cetera, it is still valid. I will tell you that that will not prevent a guardianship matter from coming. I actually include a guardianship section in my power of attorney, but it will not prevent a guardianship matter from being instituted if other family members, people who have standing, like what we just discussed before, say that the person was incompetent when the principal, that's the name of the person who executes the power, when the principal executed, that he or she was incompetent. But you should just know that. Does that? But I want to address if you have a power that was not fully executed, meaning even one you have. I always tell my clients have successor agents just in case someone isn't available, dies, whatever. Even if one was not. Did not sign, you have a problem with that power because there's been case law and attorneys have been sued since June 2021 because principals did not have, like, you sign today and you forget about it. You don't give it to the successor agents. And as a result, or even the regular agent, and as a result, the court has said, no, if it wasn't fully executed before June 2021, not good. So if you've done that and it's not fully executed, really you have to re-execute.
Okay.
Okay. Thank you. And Bill, you do genealogy. Excellent. Are wills public documents that I can see? Absolutely. As long as you can get into the court. Now, there are some wills which are, actually, I recently even saw Aretha Franklin's will. No, wait, she didn't leave a will. Who am I thinking of? John McCain's will. That's what I was thinking. Which was very good. But yeah, wills are public documents unless the court says they aren't. But yes, you can go into the court. Problem is during COVID, I think you need to make an appointment to get into the records room. Have you done that, Bill? Bill? I don't know. Anyway, I think you need to make an appointment for the records room.
Yeah, I'm at the library, so I'm speaking slowly. I'm actually, I have my own down island.
I'm sorry, Bill, I can't understand what you're saying. I'm sorry. Do you want to put it in chat and we'll read it? Oh, we lost it. Okay. Hi, Denise. Do you have any questions or do you understand everything I said?
No, so far everything is very good and very informative. Thanks so
Good.
much.
Okay, well, thank you. So does
Yeah,
anyone? Hi, Rick.
Question? How you doing? Great presentation. You really do a great job at taking a complicated subject and making it really easy.
Thank you.
Yeah.
What about a living will? Do you recommend the client?
I don't even know what a living will is. Some people have a living will and a healthcare proxy.
Yeah, what is the difference? Or are they?
That's not good law anymore. You should just have one healthcare proxy.
Okay.
That's the law. And it used to be, but I want to address that. Years ago, like 20 years ago, you would have a healthcare proxy, which would name your agent and hopefully a backup agent or two, whatever. And that's all it would do. And the living will would be the DNR or, the burial or cremation, whatever. But we do that in one document now.
Oh,
and it's called a healthcare proxy.
Okay.
Yeah, don't do two documents.
Okay.
So what about the irrevocable? The irrevocable will?
Irrevocable trust.
Yes, trust.
Okay, so the different kinds of trusts, there's a revocable trust and irrevocable trust. Most people create an irrevocable trust because they want to apply for Medicaid. Is that what you're thinking about?
Yes.
Because, people come to me and say, oh, my next door neighbor did this. My next door neighbor transferred the house to the children and kept all the money. And I went on, they went on Medicaid and they didn't have to pay for anything. I want to do that too. And I say, great. Number one, there's a 5-year look back period. So if you're transferring assets for free, gratis to your family, because you want Medicaid to pay for your health care, be aware that there's going to be a penalty period. Number two, if you do an irrevocable trust, that means, Denise, irrevocable, you can't change it, right? So you're going to lose control over all your assets. So I say to the person, do you really want to lose control? Well, what do you mean? No, I keep the assets. No, you don't. Look, Medicaid is for poor people. Poor people. In fact, I had a slide there. You're entitled to $890 in income per month, plus about $15,000 in assets. I don't know how you can live on that.
Yeah.
That's what Medicaid allows. So we all pay taxes. Let's be honest. Do we want to pay taxes? Do we want to pay Medicaid, into Medicaid for someone who has money, owns property, has assets, has bank accounts, and then just transfers it to the children so that the children keep money? What's interesting is a lot of people don't understand that. And then they think, okay, I'll get on Medicaid and everything will be fine. I'll transfer into an irrevocable trust. Very good. Then you die. And what do you think Medicaid does? Does Medicaid say, oh, okay, well, it was nice to pay millions of dollars for you? No, Medicaid slaps a lien on the estate.
Oh.
I see that in almost every estate where there is a Medicaid payment out, and you can't administer the estate without paying off that lien. Now, what incentive is there for Medicaid to negotiate that debt? When you're doing estate administration and there are all kinds of debts decedent left, you call the credit card company and maybe you pay 50 cents on the dollar or less, right? You know what I'm talking about?
Yes.
Medicaid doesn't do that. Why do they have to? They don't. You have to pay them off and full amount. So even if people think, if someone comes to you, Denise, and says, oh, I want this, say, you do realize you're going to pay the piper, whether in the beginning or the end. Okay. And one last thing I want to say about a trust, because you bring it up. A trust is not a person. A trust is an entity, like an LLC or, a corporation, or it's an entity. And the important thing to know about a trust, whether it's revocable or irrevocable is you must transfer assets into the trust. So let's say you create the Denise Tuzo, I hope I pronounced your name correctly,
Yes.
irrevocable trust. Great. Empty. You got to move the house in there. You have to put the bank account in there. You have to do whatever you have to do in there. Do you know what I mean? Because
Yeah.
if you start with the trust, that's great. And then it's empty, you've wasted time, wasted money. Did that answer your question? So be careful
Yes.
when you do irrevocable trust, and not everybody needs a trust. Just because
Okay.
your neighbor has it or your cousin has it,
Yeah.
that doesn't mean you need it.
Okay.
But
Thanks
that's
so much.
again, a discussion for another time because we're just doing a state administration.
Okay.
Let me see what that is. Bill, I want to see my dead uncle's will, who lived in Nassau County. I'm in Manhattan. He died in 1995. Okay, well, call the Nassau County Surrogates Court Records Department and ask them, do you need, can you come in? Do you need an appointment? Because before COVID, anybody could go in. It was a different world, obviously, right? But now with COVID, I'm not sure. I don't go into the records department, so I don't generally, so I don't know. I hope, Bill, that that's helpful. Okay, any other questions? Okay, it's so nice to see everybody.
Nice to
And
see you.
by the way, so you could turn this off, Mariana. Thank you. And thank you so much for having me.